Good day, class, and welcome to Introduction to Criminal Justice course. I'm Professor Darrell Ouellette. And this will be Lecture 10 of this course. Lecture 10 will consist of my talking about the United States court system. This lecture will also include the following topics: types of courts in the United States, preliminary hearings prior to trial, and I've already mentioned some of these in previous lectures. Preliminary hearings like the initial hearing, the arraignment hearing, and so forth. I'll also talk about pretrial motions in this lecture. I'll talk about types of trials. There are basically two: a jury trial and a bench trial. Talk more about that later. I'll also mention things like statutes of limitations on crimes. Few people know that on certain crimes, if they're not detected within a certain amount of time, then police cannot make an arrest or charge anyone. The lecture will also include the process of jury selection. I'll mention such things as reasonable doubt and presumption of innocence, what those are for trial. And I'll also, towards the end of the lecture, talk about the different stages in a criminal trial. And after the trial, if the defendant is found guilty, I'll talk about how the appeal process works in the United States. And I'll also mention a little bit about civil suits towards the end. In keeping up with the theme of this course, here again you see the criminal justice funnel. We're at the stage where the suspect has been arrested and charged, and we are now in the court action phase of the course. A fair and public trial is a hallmark of the U.S. court system of justice. The courts include a federal system and a state system. These are the two major systems of courts in the United States. Under the federal system, the trial courts are called federal district courts. Under the state system, trial courts are either state district courts or state superior courts. Federal district courts are for violations of federal law and crimes on federal property. There are 94 federal courts in the country, in the U.S., and judges are appointed for life by the President of the United States in consent with the Senate, with approval of the Senate. Federal judges, in turn, sometimes appoint magistrates who hear pretrial motions. Now, in the U.S. Federal Courts of Appeals, these courts hear appeals from federal district courts. Usually, there's a three-judge panel that sits. There's no jury, just three judges that sit on a panel. They vote either to affirm or reverse a lower court decision. There are 13 of these courts. There's one in Washington, D.C., and the other 12 are spread throughout the country. Now, the U.S. Supreme Court, that's the next highest court. They have 9 justices, and these justices are also appointed for life by the President of the United States with approval from the Senate. The most recent appointments are Ruth Bader Ginsburg under President Clinton, Stephen Breyer also under President Clinton. Prior to that, under President Bush, Judge Thomas, and under President Obama, there's been a more recent one whose name escapes me at this time. Now, this court reviews decisions of federal courts and highest state courts. The U.S. Supreme Court has the last word in applying the Constitution to criminal justice practices. Now, under our state court system, each state system includes both trial and appellate courts. Just like the federal government, we have a federal trial court and we have appeals courts. So does each state within the United States. Many states, like Maine, have district courts and superior courts, which are trial courts. There are state supreme courts, which are appellate courts for lower state courts. So if there's an appeal coming out of a lower state court, that is heard by a state supreme court. In Maine, judges are appointed by the governor with approval by the Senate for a period of 7 years. So state supreme court judges, or any judge in Maine, they're not appointed for life like they are in the federal system. They're appointed for 7 years. Now I'd like to talk about preliminary hearings prior to trial. I've already mentioned in a previous lecture what an initial hearing is. Initial hearing is a preliminary hearing. This is when a judge reviews bail after someone's been arrested and they cannot make bail. And at that time, they also may appoint an attorney for a defendant if a defendant is indigent, which means that they cannot afford an attorney. That happens at the initial hearing, depending on the seriousness of the charge, of course. Lawyers are only appointed if the charge on the defendant may include jail time. Otherwise, the judges don't consider the offense to be serious enough, and the defendant is on their own if they can't afford an attorney. Now, at an arraignment hearing, again, that's a formal hearing for entering a plea. It's very formal. No one talks but the judge, unless the judge requests you to say something. And this is where the defendant will make a plea, and those pleas include not guilty, guilty, guilty because of insanity, nolla contendere, which means no contest. Nolla contendere, the person is saying, I don't want to contest the charge. I'm not saying I'm guilty, but I just want to pay my fine or do my time or whatever. It's a legal term meaning no contest. There are also another preliminary hearing before trial is a probable cause hearing. A hearing where a judge reviews the evidence produced by the state prosecutor and determines if enough probable cause to have charges go forward for trial. Now, At a probable cause hearing, the attorney and the defendant can appear at this hearing as compared to a grand jury hearing. Now, the arraignment hearing is not like it's not a friendly court like possibly a juvenile court. The As I mentioned before, it's a very formal hearing. Um, it requires decorum on the part of everyone. Those causing disruption are removed in any courtroom and may be held in contempt, get a fine, jail time, or whatever. Just as the police are a symbol of authority out on the streets, the judge and courts are symbols of justice. Now, through these proceedings, the criminal justice system separates the innocent from the guilty through the preliminary hearings as well as the trial itself. Now, during the arraignment, the judge again will accept a guilty plea at that particular hearing and will schedule another hearing for sentencing. Now, as I mentioned a few minutes ago, nolo contendere has the same effect as a guilty plea and finding, except that in later civil trials, this plea cannot be used as evidence that the defendant committed the act. So if someone pleads nolo contendere to, let's say, drunk driving or some sort of crime, that plea in itself cannot be used in a civil hearing later. A not guilty plea results in a trial date and place being set later on. Now, in the guilty plea procedures, the judge does not need to accept a guilty plea or nolo contendere if the judge thinks the defendant is mentally incompetent. If the defendant does not understand what is happening and is being forced into making a guilty plea, or the plea is greatly inaccurate in terms of what happened, the judge does not have to accept it. Now, if a person's plea is accepted, then it's just as if there had been a trial. The person had been tried in court. A pre-sentence report is usually requested by the judge. The judge doesn't, in the pre-sentence report, the probation officer will do a background investigation on the defendant and usually recommends a sentence. The judge doesn't have to go by that report, but usually does to a certain degree. For sentence, the judge takes into account not only the crime involved, but also the prior record, personality, current status in the community by the defendant, and so on. Now, in this slide, I'm going to be talking about preliminary hearings prior to trial. Before trial, there are pre-trial motions. These motions are mostly argued in open court. I've listed different types of examples of motions here. Motion to dismiss charges, that's usually common. Defense attorneys will always do that. Rarely is it accepted by the judge, but they do make the motion in open court during arraignment. or at any time during probable cause hearing. They also make it during trial after the state has presented its case. There's other motions. Motion to determine competency of the accused to stand trial. Again, if a person pleads guilty because of insanity or whatever, there'll be a motion to determine whether the person is sane or not. As I mentioned, motion to suppress evidence is probably the most serious, because if the prosecution can't use some of their evidence, then they might not have a case. The defense may also make a motion for the prosecution to disclose the identity of a confidential informant. That happens a lot, especially in drug cases where a confidential informant provided information to police to go make an arrest on a drug dealer. Defense will usually confidential informants are used by the police on many cases, and their names are not mentioned in court, but there may be a motion by the defense to have that person's name released, and the reason for that is the defense will try to discredit this confidential informant as not being credible. Motion for change of venue. Venue is the place of trial, and if there's a lot of publicity on a case, the defense may want the trial to be moved to another location so that juries can be selected and in fairness to their client. Motion for continuance, that can be done by both sides, the defense and the state. Usually they want more time to present a defense, or the state needs more time to gather more evidence. Usually they're awaiting tests from the crime lab, toxicology results from the medical examiner's office, or whatever. And then there's motion for discovery. In the motion for discovery, both prosecution and defense seek to gain access to the evidence possessed by the other side. It's like having a card game, and you'd like to see the other person's cards. Well, a motion for discovery is the same as wanting to look at another person's cards. You're seeking to gain access to the evidence possessed by the other side so you can prepare better defense. Usual items available for discovery for the accused are names and addresses of prosecutorial witnesses. Discovery can also include any written statements they may have made, or all statements made by co-defendants, and the name of anyone who heard such statements. The defense may also put a motion in for discovery to get the transcript of the criminal or the grand jury minutes. They may put in a discovery motion for discovery on reports and statements by experts on issues relating to the case. Defense may want results of physical and mental tests done on their client. They want reports on any physical evidence. They want reports of any scientific tests done on that evidence. They may want anything obtained from the accused that the prosecutor intends to introduce, such as evidence like the accused's clothing, or fingerprints, or DNA. The defense may also put in a motion for discovery on any record of prior convictions of persons the prosecution intends to call as witnesses. Now, the prosecution is also entitled to discovery. The prosecution may require the accused to appear in a lineup, physical lineup, or a photo lineup, have their picture taken. The prosecution may require the accused to speak to voice ID. If a victim heard the suspect's voice, they may want the voice recorded so that the victim can identify it. They may require the accused to be fingerprinted, to be photographed. to try on clothing that is relevant to the case. They may want to have the accused submit body fluid specimens for DNA. They may want the accused to submit fingernail material, provide a handwriting sample, or other relevant materials. The prosecution may also require the accused to undergo tests the court deems reasonable. The prosecution may also want to know the defenses. The defense tends to put forth things like, does the accused have an alibi? The prosecution would like to know that because the accused may have refused to speak to the police. So if the defense has an alibi, the prosecution would like to investigate that alibi. The prosecution would, under motion for discovery, would also like to have the names and addresses of defense witnesses and any written statements they have made. And they may want to know anything else the defense intends to use as evidence. As you may have realized by now, pretrial discovery practically eliminates any surprises at trial. Now, as I just mentioned, pretrial discovery practically eliminates any surprises at trial. Now we're moving on to the trial stage, and prior to the trial, the judge will hear motions from the defense as to whether they want a jury trial or a bench trial. Now, jury trial is pretty self-explanatory. 12 members of a jury decide guilt or innocence in most states, and the decision has to be a unanimous decision. But the defendant may choose to have a judge hear the case without a jury. This is called a bench trial. Defendant can choose this in most areas in the United States, but not all areas of the United States grant this motion. To have a judge hear the trial alone is a tactical matter. This usually involves cases of that have a highly technical legal issue where a jury might not be able to understand those issues. Waiver of a jury trial would probably be opted for by defendant, and that's usually advantageous to the defendant when the case has a lot of adverse publicity. Let's say the defendant is charged in killing a baby. There's a lot of adverse publicity against the defendant, so he may want a more impartial type person listening to his defense. When there's a highly technical defense plan, the defendant may believe that the juries would be unsympathetic to their cause. In a jury trial, everyone has a right to a jury trial in felonies. This is not so in less serious cases. Unless the penalty carries a potential punishment of more than 6 months in jail or a fine of more than $500, courts do not usually grant a jury trial. In this next slide, I mentioned the Sixth Amendment guarantees the right to a speedy trial. In a bench trial, judges sometimes have to state reasons for whatever the decision was, why they found a person guilty. Juries never have to do that. A jury just finds a person guilty or not guilty. Now, if a jury decides to convict someone, that conviction may be set aside by the judge if there is belief that the beyond a reasonable doubt test of evidence was not met. if the state has to prove someone beyond a reasonable doubt, and if the judge believes that that wasn't met, and the jury still finds someone guilty, the judge can disqualify that verdict and let the person go free. The judge may issue a judgment of acquittal, meaning not guilty, or without waiting for a jury finding. If the trial is over with and the jury is about ready to make a decision, the judge can simply say, I find this person not guilty. The judge may also wait for a jury finding and then set aside the verdict if it is a guilty finding and the judge is convinced that it is erroneous. A judge can never convict after a jury has acquitted, no matter how convinced they are that the person is guilty. So it doesn't work both ways. The judge can just let a person go free, but if it does go to a jury and the jury does say guilty, the judge cannot. If the jury says not guilty, the judge cannot find the person guilty. So let me repeat that. If a judge finds that a person, there's not enough evidence to convict a person, they may decide before it goes to jury that the person is not guilty. Once it goes to jury, if the jury finds a person not guilty, the judge cannot overturn that verdict, but they can overturn a verdict of guilty. Speedy retrial refers to the time of the offense to trial, from arrest to start of trial. Speedy trial today is routine but sometimes slow due to crowded court calendars. Speedy trial provisions seek to prevent undue delay in bringing cases to court. Speedy trial provisions also seek to prevent persons from being held for extended periods of time in custody awaiting final judgment. Delaying a trial has advantages and disadvantages for both sides. The state can continue to accumulate evidence if the trial is delayed. The state can also, in effect, punish someone awaiting trial by keeping that person in custody. The defense team might welcome a delay until bad publicity cools down and witnesses' memories fade. That may be a strategy on the defense. Defense requests for continuances are a major roadblock to the speedy trial efforts of the criminal justice system. Okay, I've gone to another slide now, and this slide is titled Statutes of Limitations. Statutes of limitations are a time limit that laws have placed on certain crimes. Usually that time limit is 5 to 7 years. If a crime is committed and not detected, and there's a period of time where a crime needs to be detected in order to prosecute somebody, and generally that's a 5 to 7 year period from time of commission of crime to time of arrest. That's what we mean by statutes of limitations. After the statutes of limitations have expired, the matter involving the crime is closed. Now, certain crimes like murder, there is no statutes of limitations. Some states have no statutes of limitation on child abuse. So child abuse, as well as murder, has no statutes of limitations. For misdemeanor crimes and lesser violations, the time could be as little as 3 years for statutes of limitations. Okay, we're ready for trial, and we now have to select a jury. In jury selection process, historically there are 12 members, but it doesn't necessarily have to be that way. In Maine we do have 12. Some states have less. It can be as few as 6. 6-member juries are common in other states in misdemeanor trials. Only 14 states and the federal jurisdictions require a 12-member jury. And as I said earlier, Maine is one of them. In a jury trial, it must be a unanimous vote for finding of guilt or innocence. Otherwise, the jury is hung, and the judge declares a mistrial. A hung jury is, well, if you have 12 members and you don't have unanimous, meaning 12 to nothing for guilty or not guilty, then the judge urges the jury to come out with a decision. If they can't, the judge declares a mistrial, and that a mistrial means that it's as if no trial had ever occurred. Jury members are usually selected by chance from voter registrations. Since some people don't vote, they may not vote because they don't want to serve on a jury. Some states now take juries from driver license lists. Minors, of course, are excluded from being on a jury, and anyone with a felony conviction is excluded. Those people that are hospitalized for mental illness are excluded from juries. And those of particular occupations, like if you're a police officer, you may not get selected by a jury because you're considered prejudiced. Doctors and nurses may be excluded from juries if it has to do with a medical type case. They may have preconceived opinions about it. Both defense and prosecution participate in selecting a jury by questioning a pool of potential jury members. There may be as many as 75 people show up for the jury selection, and the defense and prosecution will need to pick a jury to hear the trial. Either side can dismiss a jury member by what is called a peremptory challenge. And of course the judge has a say as to how many of those you're going to get, how many the defense will get. If the defense does not like a particular person, they just say, I don't want this person, without having to give a reason. Same with the prosecution. But after a while, the judge may say, hey, you need to give me a reason why you don't want this person on the jury. I'd like to, this next slide, I'd like to talk about what voir dire is. Voir dire means to speak the truth. It's another legal term. It's a jury selection term where potential jurors are asked to answer truthfully to certain questions by lawyers in the case. And this happens during jury selection. Both peremptory and for cause removal are based on the jury's responses to voir dire questioning. The questioning of a jury allows both sides to decide whether or not a person will be suitable to be on a jury. Some of the questions that are asked are about whether or not an opinion in the case has yet been formed or not. They'll be asked whether the potential jury is associated with anybody on the case. jurors may be asked about their attitude towards certain types of crimes, towards people in punishment. They may be asked if they have any preconceived notions as to guilt or innocence of the defendant. In theory, the purpose of voir dire is to determine if a person can render a fair and impartial verdict. But in reality, in voir dire, both sides, the prosecution and the defense, are trying to stack the jury so that it's favorable to their side. On this next slide, I'd like to talk now about reasonable doubt and presumption of innocence. What is reasonable doubt and presumption of innocence? Well, the criminal trial demands the highest level of evidence to convict a person. They need to have the trial needs to have proof beyond a reasonable doubt that the person committed a crime. Not any doubt, but a reasonable doubt. Reasonable doubt has a higher standard than probable cause needed to arrest or indict. So you arrest someone on probable cause, but reasonable doubt is a higher standard than that in a court proceeding. Reasonable doubt has a higher standard than preponderance of the evidence in any case. Now, in presumption of innocence, everyone is presumed innocent until proven guilty. So the entire burden of proof lies with the state, the prosecutor, to prove someone is guilty. The accused does not have to prove innocence, and does not have to take the witness stand in their own defense. Now let's go to the stages of a criminal trial. What are the stages in a criminal trial? After a jury is selected and seated, the trial is ready to begin. And the following that I've listed for you here are the stages of a criminal trial, and where again the state is the prosecution versus the defense. The defense is the attorney and the defendant. After a jury has been selected, we start the trial with opening arguments by the prosecutor, which is an attempt to tell the jury what crime the defendant is charged with and how all the necessary elements proving guilt will be demonstrated. The defense may then make its own opening statement, and often does, unless the defense attorney wants to wait and give an opening statement later on. Upon completion of the opening statement, the prosecutor then presents his or her own evidence. Physical evidence such as fingerprints, testimonial evidence of witnesses or experts as to how, when, where the physical evidence was obtained, what the eyewitness evidence might be, and any circumstantial evidence gathered on the part of the state. Again, circumstantial evidence is evidence from which a fact can be reasonably inferred, such as a defendant being seen with a gun near the scene of a shooting, for example. Now, all of this evidence is done through direct examination or questioning of state's witnesses. So the prosecution does the opening arguments, they present their evidence, and direct examination means that they're going to question each one of their witnesses. Now, after each witness for the prosecution has testified, The defense may carry out what we call a cross-examination in an attempt to cast some reasonable doubt on the evidence by questioning the manner in which the evidence was obtained or analyzed, or by questioning a witness's memory, or by showing inconsistencies in testimony, or perhaps by challenging the credibility of or expertise of certain witnesses that the prosecution has put on the stand. After the defense cross-examines, the prosecution is then allowed to question the witness again on what we call redirect examination. The state redirects, in order to give the witness an opportunity to clarify any issues raised in the cross-examination. Now, this may be followed by a recross examination. That is, the defense counsel may again put questions to the witness based on redirect testimony. After all the prosecutor's witnesses have presented their evidence and been cross-examined, and after the prosecution has presented all of its other evidence, the state rests its case, meaning the state rests. They're all done presenting their case. At this point, the defense frequently moves for a directed verdict of acquittal in order to give the trial judge an opportunity to dismiss the case for lack of sufficient evidence. This is pretty routine. In most cases, the judge will not dismiss the case. If the prosecution thought they had a good enough case, the judge will usually allow the trial to continue. Again, this is usually a tactical move by the defense. However, the motion to dismiss is routinely denied. The defendant then, through his or her attorney, then introduces witnesses or other evidence that favors the defendant's claim of being not guilty. The defense may begin with an opening statement by counsel or by the attorney, but is not required to do so. Normally, defense witnesses are sworn in and subjected to direct examination by defense lawyers. Now, these are witnesses for the defense, and they will go under the same process as the direct examination of state's witnesses. After the defense attorney directs questions, then the prosecutor will cross-examine that particular witness. After all the defense witnesses have been examined, cross-examined, and examined again on redirect, the defense rests its case. Further witnesses may be called by both sides in order and cross-examined in a process called rebuttal. Rebuttal witnesses dispute the testimony of the judge's witnesses. Rebuttal witnesses dispute the testimony of the defendant's witnesses. Then the defendant's rebuttal witnesses may be called to dispute the testimony of the prosecution's rebuttal witnesses. After the final cross-examination, the evidence phase of the trial is finally concluded. Now, I've summarized what I've read in these last two slides. This is a summary of what I just said, to break it down for you. Now, in this next slide, as I continue talking about the stages in a criminal trial, usually at this point, a recess is taken in the proceedings to allow the judge to prepare instructions to the jury. A conference is often held in the judge's chambers, and the attorneys for each side submit proposed instructions for the jury. The judge decides what the instructions will be and informs the attorneys of what they will be, after which the attorneys prepare their own closing remarks with an eye to the content of the judge's instructions. Following this, first the defense and then the prosecution sum up by closing statements. The defense tries to cast doubt on the prosecutor's evidence, or some of it, and the prosecutor is allowed the last word because the entire burden of proof is on the state. And the prosecutor normally tries to show how the evidence introduced proves the defendant guilty beyond a reasonable doubt. So, in summary, the prosecutor does have the last word in a trial because the burden of proof is on the state. After the closing arguments, the judge is now ready to instruct the jury on the meaning of reasonable doubt. After the closing statements, the judge charges the jury, instructing them in the applicable points of law, in the nature and meaning of evidence they have seen or heard, and about the meaning of reasonable doubt. The judge then retires to another location the jury then retires to another location to deliberate the guilt or innocence of the accused. If agreement among jury members is reached, then they return to the courtroom and notify the judge of their decision. This is called a verdict. The defendant is then asked to stand to hear the verdict of the jury. If the verdict is guilty, the judge sets a time for sentencing, usually some date in the future to allow time for a pre-sentence investigation by a probation officer. If the jury cannot make a unanimous decisions and they cannot receive a consensus, they report their dilemma to the court. The judge then may suggest strongly that the jury deliberate further, or may instead conclude that they are a hung jury, which I mentioned a couple slides back. A hung jury is one that cannot reach a unanimous decision about guilt or innocence. If the jury cannot reach a verdict, the judge declares a mistrial. If this happens, the defendant may be tried for the same crime again before a different jury. Normally, after the verdict is announced, if a verdict does happen, the judge dismisses the jury. Judges often use this occasion as an opportunity to thank the juries for the important service they have rendered and to make a brief speech about the American system of justice. They do this because, judges are politicians as well. Again, if a not guilty verdict, the defendant goes free. If a guilty verdict, a date for sentencing is set. Now on appeals, an appeal may be requested by the convicted defendant. An appeal may be requested by the convicted defendant, now an offender, and granted by the higher court. There are time frames for appeal. Appeals must be made during a certain time frame. And before an appeal can move from a state level to a federal level, all state appeals must be exhausted. The most common appeals are one where the defendant argues they did not get a fair trial for whatever reason. Sometimes even if a defendant is found not guilty, they can still be sued in civil court, such as the case of O.J. Simpson. Now, OJ, as some of you know, was found not guilty in the murder of Ronald Goldman and Nicole Simpson, his ex-wife and her friend. Two separate juries passed judgment on former football star O.J. Simpson. The first one was a criminal jury, which found him not guilty, and that was a predominantly African-American jury from Los Angeles. They found him not guilty in the criminal trial, concluding that the prosecutors had failed to prove O.J. guilty beyond a reasonable doubt. Now later, O.J. was brought in front of another jury. This was a civil jury. A predominantly white jury found Simpson liable in the deaths, concluding that the evidence showed that he more likely than not killed the two individuals. The standards of evidence differ greatly between criminal and civil trials, but a lot of observers believe that the makeup of the jury was the primary reason for the two different verdicts. Both juries were chosen after an intensive research interrogation by lawyers on both sides of the case. Each side spent thousands of dollars on jury consultants who were not seeking jurors who would be impartial, but attempting to choose jurors they felt would favor their case. And they tried to block jurors who the research predicted would be favorable to the other side from being chosen. So, civil courts do not need as much evidence as a criminal court. And in closing, I'll say that just because you're found not guilty, you can be sued for anything. As I'm not saying that O.J. Simpson was sued for nothing. I believe he was guilty. Again, he claims his innocence, and most of his search for the killer of his ex-wife has been on golf courses until he got into more trouble for armed robbery and is sitting in jail. That is all for this lecture. Have a good day.